Dr. Chaladurai, sir?
Yes, yes, sir. Yes.
Yes, sir. Can we start, sir?
Yeah, time started.
Yes, sir. I will take 1 minute for formal introduction. So then the session hand over to you, sir.
Yeah.
Yes, sir. Sir, your voice is not clear, sir. Good evening to one and all present here. We are warm welcome our 3 days international workshop under the title of Intellectual Property and Rights, which is organized by scholarsgate Research Training Institute, Tamil Nadu, registered under MSME Government of India. So today resource person, Dr. G. Chaladurai. So he is Assistant Professor of Zoology, St. Joseph College of Trichy, Tamil Nadu, India. He taken the first day session. So today's sessions is segregated the two part. First part taken by the Chaladurai sir, second part taken by me, Sadish Kumar Sankar. Meanwhile, if you have any queries last 2 days session, you can ask at any time. So your certificate and your meeting record already we shared 2 days recording. So today recording it will be shared by tomorrow. Apart from that, after the 30 minutes, so meanwhile the 7 o'clock or 7:15, so we will share by the feedback link, so feedback and Google review link. So you please give your valuable feedback, both feedback. So both big feedback is most essential for us. So once we get all the feedbacks, then only we can further your process your certificate and complete the process. So if you have the time is tomorrow afternoon before 12 p.m. until the link will be open, so you can submit your valuable feedback. So thank you so much for giving this wonderful opportunity to conduct this 3 days intellectual property workshops. So kindly learn so many things. I hope the sessions will be more helpful for you. So I'm also interested to learn more things at today's session. So the session hand over to Dr. Chaladurai sir. Chaladurai sir.
Yes, sir. Yes, yeah.
Yes, sir. Please carry on the sessions.
The PPT, can you please give the PPT?
Yes, sir. 1 minute. Yes, sir. My screen is visible now, sir?
Yeah, yes.
Yes. Yes, sir. You can start.
Okay, yeah. So, good day. Good day to everyone, and welcome to day 3 of our complications discussion on intellectual property rights. Myself, Dr. Chaladurai. I know you know well me.
Sir, your voice is not clear.
Yeah. So myself, D. Chaladurai, as an assistant professor of zoology at St. Joseph College, Tiruchirappalli, Tamil Nadu. So today I will be walking you through various aspects of patents and the rights associated with them. So we will cover the key concept related to grant patents and patent rights, and what you as an inventor or co-owners can export once you have a patent. So let's going to be start things. So this is our agenda. This is the today's session agenda. I hope you will be learn after the completion of the sessions these agendas. So here what we'll be discussing today, the grants of patent. The first thing is how patents are awarded. So already I hopefully the Sankar sir has told detailed about what are the forms are available to file the grant patents on yesterday. So here the first agenda is the grants of patent. That means how patents are awarded. The second agenda is form, extent, and effects of a patent. So what patent covers and its legal boundaries. So this second agenda, we will cover on what a patent covers and its legal boundaries. And third agenda is rights of patentees. The third agenda is the rights of patentees. And what is the rights of co-owners. So in this third agenda, we will cover on what rights you gain as a patent holder or co-owners. So by end of the session, you will have a clear understanding of the patent process, its benefits, and the responsibility that come with it. So, hopefully, you will know about today's session agenda. So next one thing is the first agenda is a grant patent. So now let's talk about the process of grant patent. To obtain a patent, your inventions need to meet the 3 criteria is very important. So what is the three criteria? The one thing is novelty. Okay. So if you have an idea, that idea should be a novelty. Its very thing is, so the novelty, it must be a new idea that has not been publicity. Okay, that has not been publicly discovered before that. Already we have discussed on day of first novelty. What is the meaning of novelty? So the first key criteria for the grant pattern, the one thing is novelty, and second criteria is non-obviousness. So the invention must not be something that an expert in the field could easily think of. So invention is very difficult to thinking, and it is not easy to think of. So that invention is only applicable to get the grant patterns. Now we are talking about only the grant pattern, not for grant publication. So the grant pattern is the last stage of patent holding, patent getting. And third important thing is utility is very important. Utility in the means the invention should be useful and serve as a practical purpose. It's very important. So the invention should be useful and serve as a practical purpose. Already discussed in first class. So invention should be more applicable to the society or industrial applicability. So that think ideas only to get the easily for the grant patent. So these are the criteria. So another important thing, some steps are there for getting the grant pattern. What are the steps? Okay, what are the steps are there? I will tell one by one. What are the steps for getting the grant pattern? And the first step is patentability. Determine the patentability, the first step. So far, to ensure your invention is novel and of course non-obvious and useful to the society. So before that filing, you should be conduct a superior art search to search if similar invention is already existing. So before going to be file of your invention or idea, you should be aware about that invention is already existing or not. It's very important. If it is already existing, means your invention is not an invention, your idea is not an invention, so it is completely waste of money. Okay, so main thing is the first steps for getting a grant is determine the patentability. So your idea is quality and the idea is maybe more innovation or more non-obviations and more useful now, you can go to file a grant level up to grant level. The second important thing is prepare the applications. I will show the next slide how to prepare the application of patent draft. That is a patent application is nothing but patent application. So here to write a detailed patent applications. The second step is very important. So according to the patent granting, the second step is very important, but preparation of draft is very important. The draft is unique already means not we get the grant up to the granting level. So the first preparation of draft is something is title of the invention. It's very important. So it's going to see in next slide the preparation of applications. I will show it. So the next important thing is file of application. Third step is file of application. This is the third step for patent filing. So submit your application. So make the draft. Then you can submit your application to either e-filings or offline systems. Okay. So submit your application to the relevant.
Sir, your voice is not audible, sir.
Yes.
Sir, your voice is not audible, sir. It is some unwanted noises came.
Yes. What about now? Is it audible or not?
Yeah, yes, sir. Yes, sir. You can carry on, sir.
Yeah. Yes. Third step. The third step is it's a very important step. The title of the third step, name of the third step is examination of process. So after filing, your application will be examined by the patent examiner, that is a control of the examiner. They may be raise some issues like your patent is already existing now, they will be rejected. The idea draft will be rejected, or else sometimes it may be objection. Someone may be claiming your innovations already existing, or else your innovations is my own innovations. Okay, so whether depending upon your idea. Okay, so third important thing is examination of process. Next important step is granting the patent. If the examiner finds your application meets all the criteria. Next, if the examiners find your application meets all the criteria, they will issue a notice of allowance after paying the record fees. Your patent will be granted. Okay, the granting of patent steps. So after that, what is the last step for the getting of patent, grant patent? Maintenance. Already I told you the 20 years is the validity for the patent, process patent. So once it's granted, you will need to pay the maintenance fee at regular intervals to keep the patent. The 20 years one time you have to pay for renewal purpose. So these are the steps for getting a patent. So I already told you. Once again, I tell you, the first thing is determine the patentability, then file of application, the examination process, then granting the patent, then maintenance. Next slide, please. So next slide.
Yes, sir. I change it, sir.
So this is the application. This is the patent receipt fees. This is my fees, my patent application fees. I have filed on invention. It is only up to the publication, not for grantor. My innovation title is the isolation of bioactive components molecules from the marine gastropod. So as of now, only I have extracted bioactive compounds. So on the day I have filed only the idea. So far I have filed only a Form 1 and Form 9. So the total expenditure of this patent only 4,100 rupees around, because I not filed in Form 18. Okay, I did not file the Form 18 so far. The total expenditure of that patent fees is only 4,100 rupees alone. So for getting the patent publications. Okay, so next slide, please. This is the current grant patent certificate is issued by the Patent Office of Government of India. So in that certificates, you may have seen that the patent number, then application numbers, the date of filing when you are filing that invention to the patent office, the patentee's names and the title of your invention. And bottom of the certificates, the control of the signature, that is the e-signature is there, the control of patents. Okay, this is the patent current grant patent certificate issued by the Government of Patent Office of the Government of India. So next slide, please. Okay. So the next slide is title of the preparation of applications. So in previous slide, I have told you how to prepare the patent draft. It's very important. Okay, the first is very important. The first thing is preparation of applications. Like first thing is innovation, title of your innovations. So before filing your idea to the Indian Patent Office, just now I told you your idea is innovative and no one is not available to anywhere. It is not already exiting, so you can't fix it. It is a new title. It's not available. It is not available. So far, the first thing is the title of the invention is very important, and second important one thing is abstract, and second important one thing is abstract. Okay, so after title of the invention, the next important step is abstract. You have to make that abstract within a 10 to 12 lines alone. The abstract. Okay, so next, background of your invention. It's very important. Background. Next, third step is the background of the invention. So you have to write the background of your invention. For example, sir, I have an idea. That idea is like a development of a drug from plant extract against the COVID-19. That means you have to write the background of about the COVID-19. What are the drugs are available, the current scenario, you have to write it. Okay, it's very important. The next important thing is detailed description of the invention. What you have, what you are going to be studied, what is the description of your invention. That is very important. The description part is very important. The another important one thing is patent drafting, the claims. So the claiming is very important. The claim is not good. Good means our application will be rejected. So claiming is very important. According to the preparation of application, the claiming part is very important, and also the claiming part should be write only the point by point. How to write only point by point. So the claims defining the scope of your protection. Okay, why you have to protect your invention? What is the reason? What are the benefits to the society? It's very important. So you have to write only the point by point. It's easy to understand the examiners. So that's why I'm telling. If you are writing in paragraph, means it will be difficult to read out it. Examiners. So far, whatever it is, maybe you have to write only point by point is very important. And last important steps for preparation of application is drawings. This is mainly applicable for mechanical engineering and engineering background students. Okay, for example, civil engineer you may have create some layout of the designs or structural engineers now, and that is very mandatory. So the drawing is not mandatory for all the applicants. For example, biologies and commerce field and domains is not, the drawing is not applicable. So for here, the drawing is if applicable only for it is necessary. You have to file it. If you have to merge it, or otherwise you need not to bother about making the drawings and all. Okay, so fine. That's very important. So and that also about the preparation of application. So next step, please. It's very important. Next one thing is, so a pattern, next important extent of the pattern is the topic, the agenda 2, extent of the pattern. So as we know, a pattern provides a protection for a specific invention alone, but it's a territorial. Already told you, if you're an Indian citizen, you have to, if you are filing your invention to the Indian government, your pattern only authorized by the India alone, not for other countries, not be claimed to the other countries. It's very important. So for this means the rights are granted by the patent are only valid within the country or region where it was filed. If you are filing in the Indian patent, you have to claim, you have to protect your inventions within India alone, not for other countries. For example, I have mentioned some many examples I have mentioned in the slides. For example, if you file a patent in India, your rights are limited to the India. Unless you file separate patents in the other countries alone, then only you have to claim for your invention to the other countries. Okay, the duration of these rights typically for 20 years alone from the date of the filing. Repeating, I'm telling you the duration of the filing. You have to protect your invention only up to 20 years. Okay, so far, if you are filing a patent in the India, your rights are limited to India, unless you file a separate patents in the neighboring countries or other countries. Okay, it's very important. So next slide, please. Yeah, next slide, please, sir. Please move on the next slide.
Yes, sir. Yes, sir. Yes, sir. I change it, sir.
Yeah. Please. Okay. This is one of the examples. Territorial pattern. Let's talk a real world example to illustrate of the concept of territoriality. Suppose a company of patents, like I have mentioned one example, a new water purifier in India. Indian citizens have made on a new water purification system. The patent technology in India. However, if they wish to protect their invention in the other country, they need to file a separate file to neighboring country. For example, I want to file my invention to the America or Australia, UK. You have to file a separate countries. So there is one document is there that will be available on the. For example, such a Brazil. Brazil is must to file a separate one. Next slide, please. Want to show examples of territoriality. So for here, some examples I want to show here. For Brazil, okay, now in the Brazil, they must to file a separate patent protection in those regions. On the other hand, the European patent offers protection across the multiple countries that are the part of the European Patent Convention. So, you know, the European Patent Convention, that means, you know, that the European countries, some of the countries are merged with the European countries. So you will be file your invention to the European UPC system. European Patent Convention system means what are the countries are covered, what are the countries are authorized under the UPC convention. Now you need not to bother about to what is called you not to confuse, or you will not to protect separate file to the countries. So what are the countries are under EPC means you don't need to file a separate forms to their country. Okay, unless or otherwise, other European countries means, for example, Brazil is the South American region area. So if any persons, for example, if any person selling your product in the Brazil's country now, you may be claimed to that a person in that particular country's area, because Brazil is not a European country, no, so it is not covered by EPC convention systems. So far, on the other hand, like European patent offers protection across the multiple countries that are part of the European Patent Convention, simplifying the process of European justice systems. Okay, next thing is. So another example is that like US patent. I want to show the another example. Examples of US patent. So another examples here, the patent granted in the US. Suppose a company develop a new product like such as artificial intelligence algorithm, that you well about the AI technology nowadays, So if suppose a company, which is located in the US country, so if suppose a company develop a new devices like artificial intelligence algorithm and the patents in the US. And the patent protects the technology exclusively within the US one because that person only filed to the US country. So far, they can prevent others from using. So once that person's filed that US country US patent, that means they can prevent others from using and selling for making the same algorithm in the US countries. Okay. So however, outside the US, what will happen? However, the outside the US, such as the Canada or India, they would be needed separate patents to ensure the rights. Is very important. So that highlights the importance of territorial protections when filing for patent alone. So suppose an Indian US citizen can file to the invention to the US government now, that invention is only applicable to US countries alone. Unless or otherwise, if any persons may develop that product in the Canada or India, they can be selling at like what making that, because that people, the US people is not filing in that India or Canada like patent office. So that is main important. Next important example is that next please. 𝒊𝒈𝒕𝒆𝒄𝒕𝒚 is one of the device. It's a device. It's best examples of US patent. It is this 𝒊𝒈𝒕𝒆𝒄𝒕𝒚 hold the exclusive patent for the algorithms that powers the AI's ability to provide the personal health insights based on the continuous learning. So this 𝒊𝒈𝒕𝒆𝒄𝒕𝒚 system can able to detect that a person's sugar level or blood sugar level or diabetes or cancer, anything else, it may be detectable. So far, this is one of the best examples of US supported grant patent, or of course, many of US grant patent is there. So they recently launched that patent. So that's why I mentioned this slide. Next important thing is please move on to the next slide. So another important thing is next agenda is effects of the patent. What is the effect of the patent? Once you file and get the grant certificate from that country, after that you will be things like a patent gives a holder for exclusive legal rights to the invention, the particular invention. Okay, so these rights allow the inventor or prevents, like for example, this patent allow the inventor to prevent others from making or using, selling or importing that particular patent technology without the permission of that person. Okay, for example, if I'm making a new drug, from the animal tissue, I got also the patent from the Indian government. So after getting that patent, I sell that product to the companies or by a company, or else I'm selling to the society, so that I can able to making the product using and selling to importing to the other countries or neighboring countries. But if any person the same product will be making and using, selling to importing, that means I raised a complaint to the court and get some money. Like for example, what are the costs I have lost that now? I'm getting that money from that company. Okay, it's very important. So what are the like for example, it's another important examples I want to show here. Like if a company patents a new solar panel in India, okay, I have mentioned that a product. That product is already granted from the government of India. In that product, some future is there. Like once they got that patent from the Indian government, especially the grant patent, they can able to manufacturing the solar plants in India, a license to the technology to others, and prevent anyone from the copying or selling the similar products in India without the consent permission, without the consent. Okay, so this exclusively empower the inventors to capitalize on their invention by either producing the product themselves or licensing it for getting the profitables. Very important. That is the main importance for who have got the grant patent from the particular field. Next. So another example I want to show here. Please move on the next slide, sir. Yeah, so next slide. This is one of the examples, like pharmaceutical industry. The patents are especially crucible industries like pharmaceutical deals are daily, like for a monthly once time, pharmaceutical, especially India, they are getting a grant patent, especially for in the field of pharmaceutical, because there are plenty of new molecules, bioactive molecules or chemical molecules against some respect to diseases. So for here, crucible in the industries like pharmaceutical industries, where the companies invest the millions in the research and development. If a pharmaceutical company is a new drug, they gain only up to 20 years for protection. As I told you, if I'm, for example, if I'm making a new drug from that from particular biological source now, and also I got a grant patent, and I have to sell to pharmaceutical industries or any R&D research and development industries now. I have protect that in innovations up to only 20 years. After that, I have to spend some money to renovate that, renewal that what is called renewal that particular invention for getting more profitable. Okay, so far during this time, no competitors can produce a similar drug without risking a lawsuits for patent infringements. Okay, so during that time, 20 years, up to 20 years, if anyone making that same drug from the particular biological source now, I can raise a complaint to the court against that persons. Okay, so if they do means someone fitting my idea or someone fitting my molecule secret, like patent secret or formulation secret now, the patent holders has the rights to sue for damaging, reinforcing the importance of patent protection and safeguarding to intellectual property. Once raising the complaint to the court, if the novelty is, if it is a true conversation, and also if it is a true, okay, this is a real thing, he is the only a person to invent that product now, the court will be give the judgment to that particular inventor and claim some amount against who has filtered that product and marketing that. Okay, so they will be get some amount from that 10%. Next slide, please. And also additional patent examples, like for examples, these are some additional examples. The first thing is wireless charging technology systems. Okay, smartphones and the electrical vehicle batteries. Second, and the genetically modified crops. Okay, you may have seen day by day the plenty of agricultural new innovation system will be forming in India as well as the world. Okay, so genetically modified crops, and another important EQ algorithms for AI technologies and medical devices. So MI and AI technology, these are the new systems will getting easily for grant patent, because some, for example, so the pharmaceutical companies, so once two persons will be filing the patent to the patent office, and the one person have make that innovated that like a drug from the plant extract, another one person develop the medical devices using by AI now. The easily the AI device nowadays, the examiners will be accepted a more number of pattern on only the AI system, because it's most easily to handle to the society peoples, and also what is called it's more reliability, so we can able to remake it. That's the main thing. So that's why the patent officers, patent examiners, they are preferring grant, especially for a grant patent on the field of medical devices and algorithms, other than the drug pharmaceutical industry, because the pharmaceutical industry every time the pharmaceutical drug will be changes according to the environmental condition. So once we make that product from that particular biological sources now, that product is not stability for until 1 year or 2 years, because it may be changes, because this chemical structure may be changed or may not be changed. So for patent authorities, they mainly prefer to medical devices, especially AI and MI devices only. Next thing. So next slide, please.
Yes.
So another file. This file is request for making the patent application outside the India. Okay, outside the India. So for here, if any persons like to protect your invention to the other than India, there is on a form is there. That form name is request for permission for making the patent applications outside the India. The name the form number is 25. Form 25. Maybe search on the IPR office website on the column of patent. So it is a formal application made to Indian Patent Office when the inventor or applicant in India wants to file a patent in other countries, for neighboring countries or Sri Lanka and all other countries, before filing the same patent in India or without filing in India. Okay, how to get the permission from the Indian IP office, because we are the Indian citizens. Okay, fine. So this is the form. Next one, please. Next. Yeah. So this is the patent search. So many databases there. This we can anyone to easily accessible this patent is free of access. Simply you can search on the Google Indian patent search. Once you search, there will be one window is open. That windows look like that. Patent search, patent e-search, and application status. Okay, fine. So here you have to mention like if sir I need if any persons I have an idea. The idea is related to devices. I have an idea devices. That idea is coming under AI-based idea. I want to check that the idea is already existing or not. The people we are going to see in that website, especially. And to see that especially, we have to put the title of your invention and check the date from which date you want to see that the idea is existing or not from and to. Okay, simply you can note it down. The next slide, please. Yeah, this is the application status. So once you have filed invention to the Indian Patent Office, then immediately you'll be getting the application number. Okay, application number. That duration of the publications for 45 days to 18 months. Okay, 45 days to 18 months, or else 2 months, depending upon the early publication, depending upon the base of the fees, or else how to, sir, I need my invention to get the within a time. And then what should I do, sir? Is there any procedures? Yes, it's procedures. The early publication system is there. How to pay some amount to get the early publication for your invention. So once you get the application number, you have to check regularly by using this website. Simply you can click on the application status and put your application number and enter the captcha. Click on the show the status, then you will be show your application whether it is accepted or published or under examinations. Okay, the next images is already, this is my invention. My invention is already accepted and published in Indian Patent Office. Okay, fine. So next slide, please. Okay, this is a slide. This slide shows the some official websites of major patent offices in various country. Note it down. Like I have mentioned a few countries like USA, European Patent Office, Japan Patent Office, and Canada Intellectual Property Offices, and Australian Patent Offices. Okay, so many countries, many IP offices, many countries there. So I have mentioned only very few and only developed countries like USA and Japan and all. I have mentioned it. Okay, so please make use of it. The next one, next slide, please. Yeah, this slide is on form. The form number is 29. The name of the form is request for withdrawal of the application for patent. So maybe once you file that patent, you get that also get the publications. After that, I don't have pay, I don't have money or any other circumstances now. You have to file one form for withdrawal. So, the reason, for personal reasons or any other reasons now, I'm not interested to file my inventions in India, or else I want to file to other countries now. And the reason a form is there. The form, you have to fill that form and I'll say sign it. Then you can e-filing or operating system. Okay, next. So, okay, so next slide is it's important file. Once you got the grant pattern, okay, so you got the grant pattern, then you'll be named as a patent holder that particular invention. So you'll be having some rights. The rights are right, like exclusively rights. The first thing is exclusively rights, and second one is rights to assign or license, rights to sue for infringements, and rights to exploit. Okay, so we will be see one by one what is the meaning of exclusively rights. So once you got the grant patent from the respective country, the patentee has the exclusive right to prevent others from making, using, and selling or distributing the patent invention without your permission. So that is known as exclusively rights. Okay. So next type is rights to assign or license. That means the patentee can assign or license the patent to another parties. So I want to share my invention. After getting the GAN patent, I want to license to my invention to other parties now. So that you are because this is your invention, so your choice is only very important. So to other party means allowing them to use the invention under some agreed condition is there. There is one form is there. So they have to fill between them both patentees and other third parties, okay, or another parties, and both of them put sign in front of the form. Okay, very important. So next important thing is rights to sue for infringements. If that means if someone or anyone use the patented invention or invention without permission, if anyone producing or manufacturing or selling your invention without permission, that means the patentee can take the legal action to seek the damages. Like your problems, what are the problems you have faced during that time now, you can raise the complaint to that court, and the court will be decided whether it is for your real own invention or your barrier too much is now. They will be the damage like for the unpermitted persons, like third person without permitted persons may give some amount to you. Okay, and last important thing is rights to exploit. The patentee can use the invention commercially, including manufacturing and selling product based on the patent exploitations. Okay, after getting your particular invention, how to exploit your invention to the society, because the main motto of the patent office, your patent, your idea, it should be useful to the society. That's why the main important for the rights of the patent is to use the invention to commercially, or else if you are making your invention is the skincare invention or AI based health devices or AI based motor two-wheelers motors or four-wheeler motors now. If you got that grant patent from that particular invention now, once you got it, you can make that product to sell it the peoples. It's very important. Someone may be helpful from your inventions. The main things, that is the main motto for the IP in India system. Okay, fine. So next slide, please. Yeah. So next slide is very important slide. Rights to the co-owners. So what do you mean the co-owners? That means if a patent has a multiple owners,
Sir, your voice is not audible, sir. Sorry for the inconvenience.
Yeah. So this slide is rights to the co-conveners, which co-owners. That means if patent has the multiple owners, sometimes it may be 3 or 4 or 5 owners may join to produce a invention. That means a co-owners. Okay, so here some co-owners also have some rights. That means equal rights to use. The co-owners of a patent generally have the rights independently use or exploit the patent invention without the consent of the other co-owners. So for what are the owners are there in your granted patent certificates now, all the patents are equal rights to selling or manufacturing your goods. Okay, it's very important. So next, licensing. Each co-owners,
Sir, your voice is
others co-owners. Yes.
yes, sir. Your voice is not clear.
What about others, please? Ensure voices are audible or not?
No audible, sir.
Low audible.
No,
It is
now
not
audible.
audible. It is
Oh,
not
your
audible.
voice is cracking.
It is breaking too much actually.
Now, okay, sir. Please carry on.
So next rights is wait. And a third important rights is revenue. The revenue of sharing is very important. The revenue of sharing. The co-owners are usually entitled at an agreed upon share of any profits or royalties from the commercialization of the patents. So that rights are applicable for co-owners also. And another rights is enforcing the patent rights. That means the co-owners may need each other consent to take the legal action for the patent infringement depending on the justical and agreements. So these are the rights of co-owners also. So for whatever it's a grand patent, that certificate, what are the names are there now? Each persons, okay, each persons, the patent holders have a rights for all the rights, like exclusively for all the rights. That's very important. So rights of the patentees and also the rights of the co-owners. So next one is, yeah, so that's all about our agendas for today. So in this session, we have seen the grants of patent and forms and what are the rights of patent is. The remaining rest of the portions, the proprietor of the company will be deliver that pending of the topics. Thank you. Satish Kumar sir will be handling
yes,
the
sir.
remaining of this.
Yes, sir. Yes, sir. Yes, sir. My screen is visible. Rajesh?
Yes, it is visible.
Okay. Sir, before starting my sessions, I want to take a few minutes for dear participant. Do you have any queries? It's a last session, so last 45 minutes. You may ask this time. So once finish this question and answer session, then I start my session. If you have any queries, please unmute yourself and discuss with the resource person, please. Okay, I think there is no question from the participant side. So, dear participant, can I start my shall I continue my session?
Yes, sir.
Yes, ma'am. Thank you so much. So, good evening to everyone.
Sir, excuse me, sir. Before starting session, can I exit the session?
Sorry, sir.
So, shall I exit my session, sir? Shall I exit my session?
Yeah. Okay, sir. Yes, sir. Yes, sir.
Yeah,
Yes, sir.
thank you.
Yes. Thank you, sir. Thank you so much. Dear participants, I think you have clear idea about the patent filling and what are the components available in the patent process. So what are the steps are involved in the patent process. Yesterday also I discussed more or elaborately. So today also this the Chalazur discussed elaborately. So if you have any queries, you can stop at any time. So we can discuss. Once you solve your issues, then we can continue the session. Today's session, yesterday I have completed till register of patents. So yesterday's session that you know that register, what are the content it is involved in the register. The register is available in the patent office. So the patentee name and address, grantees, and any assignment is there, any transmission of the patent is there, or any amendment, extension, or revocation of patents, every details it will be stored by the patent office register. So now I am starting from the power of controller. So the controller is the under the section 77, the article 1970, Patent Act 1970 is deliberately illustrated. The power controller is having the enough powers, is having the topmost power of the patents, whether it's granted or rejected. So based on the examiner report, based on that, based on the field of invention, it is really novelty work or is unnovelty work, it is a copied work. So everything, the final decision is taken by the controller. So I have in this slide I have list out what are the powers is controller having that while during the patent process and patent office. So here I am first one I have list out here the summoning and enforcing the attendance of any person and examining him or her. So any one of the applications, you know that, so is already maybe granted the patent also, or is ungranted patent also. The controller have rights for calling that particular patentee, a particular invention person. So he have the rights for examining that person at any time, at any cost. The power, the controller having that type of the power. So next one is requiring the discovery of protection of the any document. So any documents before granting or after granting, the power controller having the power, he analyzes whether it's real, is novel work, its discovery is really worthful or not. So that is the no, it is not possible. It is not only for the before the granting, so after granting also. So you know that yesterday I discussed the post grant opposition. So any post grant opposition come. So any one of the person, you know, first you take this scenario. So you are the patented person. So your patent is granted, but within the 12 month, any one of the person, any one of the interested person is filing the post grant opposition. So that time the controller have rights for analyzing the discovery of that granted patent. So the controller having that particular exclusive rights for us for that. Then receiving evidence on affidavit. So once the any infringement is happened, so the patent is wrongly patented some person. So that type of the issues it will be happen means that time though the patent should be amendment. So that time the controller will get the evidence of affidavits. So who are all involving this type of that activities. So all the type of affidavits the controller may ask to the any patent person or any applicant. So the applicant will be applicant will not refuse that giving the affidavits. So the power, the controller having this type of the power also. Then issuing commission for the examination of witness and document. So once the patent is granted or before the patent granted, the pre-grant opposition, any post-grant opposition is came from the knowledge of the controller. That time the controller may form the commissions and again they examine that particular invention whether it's really workful or not, really is invented one or wrongly the patent is obtained. So all the document is cross verified by the controllers having the enough rights for that. Awarding cost. So if you are going to filing your patent by physically, so you want to pay all the fees. So all the fees is collected by the controller only. So no one can collect the fees. So you know the patent agent also is not eligible for the collecting fees. So you can directly pay that patent office at the name of the controller. Then reviewing his own decision, the application made with the prescribed time, prescribed manner in the own decision. So the controller get the report from the examiner, but his own decision also it will be play the vital role for whether the patent is grant or non-grant. So in this prescribed time, so the own decision is playing the vital role. So whether the patent it will be granted or the patent is involving some infringements, already the knowledge is available in the public. So any type of the decisions he can take. So this power it will be having for the controller. So that any other matter which may be prescribed. Apart from that, all the decisions regarding the patent and pre-grant or post-grant, the controller is the topest person for taking the decision. So apart from that, it is not possible for appellate. So after the controller, if you have any controversy, the controller is not understanding your invention is truly novel, means you can go to the appellate board. So in that appellate board, it's having that the judicial person, so that appellate board decide for that. But in this case, so in the patent office, the controller is the topest person for taking the decision whether the patent will be granted or not. So working of patent. So patent, how it's working under the Section 32 Patent Act 1970, it will be describing the clear manner. So the general principle applicable to the working of patent invention as followed: that patent granted to encourage the invention and secure the invention are worked in India on commercial gain and the fullest extent and reasonable practicable without undue delay. So patent, first of all, the Patent Act, why the Patent Act is coming in the force by the Indian government. So first one is it is a safeguard the invention and safeguard the inventors. So that is the most important thing. So the patent will be acted for that without any delay. So if the invention is came, so the applicant is applied to the patent. So as soon as possible, the patent office employees also try to as soon as possible complete the process and publish and grant the patent. So patent is normally, you can know that. So this is the most important thing. So how the patent is what is the basic working of the patent? The patent granted to encourage the invention, secure the invention. That is the most important two key points you want to keep it in your mind. So second one is that they granted merely to enable patentees to enjoy the monopoly for importation of patent article. So if you granted the patent, so if you get the patent for your particular invention, you are the monopoly. So there is no existing things available in the market. So you are invented new things, that right is in your hand only. So you can give that any one person the licensee or assignee, or it maybe the person is deceased, means that time that the monopoly transferred to the legal representative. That will be happen. But the patent holder is a monopoly, so he have the rights for reselling. In upcoming slide, I discussed about the compulsory license. What are the compulsory? Why the compulsory license is required? So what are the criteria has to be followed as getting the compulsory license? There is a time duration also is there. So we will discuss in the later. Then that the production and the enforcement of patent rights contribute to promotion of technological innovation and transfer and disseminating the technology. That is the most important things under the Section 82. The working of the patent is insisted. The protection and enforcement. You have one idea, you have one prototype, or you have one new things. It will be promote the technological innovation. It will be promote the technological advancement in our society. So it will be reach to the community and the specific community. So it will be then only it will be worked out, the advancement it will be executed, and it will be more helpful for others. So if you have the rights, that's not there is no question for that. You have the rights, but your invention behalf of you, any one person getting the compulsory license, the increasing that promotion your work, and it will be helpful for the innovation and the invention of the technological medium. So that is the most things. It will be under the section 82 and C. It will be denoted like this. So under the continuum of the working of the patent granted do not impede production of the public health and nutrition and should act as an instrument to public interest, specifically sector vital importance, socio-economic and technological development of India. The patent is granted. Once the patent is granted, the patent is protected. The invention is protected, but the base from this invention, the public health, it may be affect or not. So sometimes you know that previously the Chelladure had discussed several things about the pharmacological invention. So you know that the chemical composition, it will be vary, depends upon the atmosphere level also. That time when it's going for the invention, that time it will be good, but after that it will be chemical composition, it will be vary, the chemical structure, it will be vary. So it will be create the huge implications, huge impact for that who's taking that exact drugs. So that types, here the Patent Act 82 is clearly defined that once the patent is granted, the patent is protected, but public health is not under the public health is not protected under this act. So it will be varied. So it depends upon that time. It depends upon the time. So next, that patent granted do not any prohibit central government in taking measures to protect public health. It's the same things. The section is a continuation of the section D. It will be E. So the patent are granted to make the benefit of the patent invention available at reasonable and affordable prices to the public. So once the patent is granted under the section 82, the invention, as much possible, it will be the reasonable and affordable price to consume the public. So that is one of the most important criteria. So because I'm the inventor, I have all the rights, I have determined my price of that invention. So it is not possible for that. So under the section 82, so you want to give that give your invention, give your product to the reasonable and affordable price to the public. So this. So then I have moved to the compulsory license. Already I told that there are if the patent is interested, or if patent is interested, is assigned to one person, is giving the compulsory license, or so within the time period. So within the time period or after the time period, anyone can apply the compulsory license for particular invention. So under the section 84, it will be clearly denoted that at any time after expiration, of 3 years from the date of grant of patent, any person can request to the controller for compulsory license of patent at any of the following grants. So after 3 years, now now your invention is getting granted. So after 3 years, within 3 years, you want to disseminate your invention to the public, or your invention give the technological invention is used for the technological advancement with the economical significance. But if your invention failed within 3 years, means anyone can ask the compulsory license in the particular invention. That is the section 84 is clearly denoted. But what are the things we should follow while you are asking for compulsory license? Means I have listed one by one here. There are 3 different type of ground is there. So one is that reasonable requirement of public with respect to patent invention have not been satisfied. Your patent invention is not satisfied for the public requirement. So that time within 3 years, your patent invention is not satisfied to the public, means anyone can apply for the compulsory license and get the compulsory license. He tried to satisfy the public requirement. This is the first ground. So second ground, that the patent invention is not available to the public at the reasonable, affordable price. I am the inventor. Previously, I mentioned that I am the inventor, so I have fixed my rate, fix the rate as per my wish. It's not possible. So your patent invention you should be given for that affordable price under the section 82. But if you are failed to give your patent invention in the affordable price to the public means within 3 years, then after 3 years, anyone can apply for the compulsory license. So third ground is that the patent invention is not worked in the territory of India. So the patent invention is not worked in the territory. It is not reached for territory of India. Means so your invention it is not clearly disseminated to the public. That is the meaning of that. So that time within the 3 years. So everything within 3 years, no one can apply for the compulsory license. After the expiration of the 3 years once from the patent grant, so anyone can apply compulsory license in any one of the ground is applicable for the work. So revocation of the compulsory license. So what are the factors? So this is the criteria for applying the compulsory license. If the person who hold the compulsory license, who applied and get the compulsory license, failed this criteria after 2 years. After 2 years, that here you have mentioned here, the compulsory license possible to revoke after expiration of the 2 years from the date of granting at any one of the following ground. So after 3 years, you can apply for your compulsory license. After 2 years, you can satisfy these 3 criteria. So if you are satisfy these 3 criteria, the compulsory license it will be revoked. So I have mentioned here same things. The patent invention is not worked in the territory of India. So within 2 years, you want to disseminate that particular invention is territory of India. So otherwise, the compulsory license it will be revoked. And the second one is the patent invention is not satisfied to the public requirement. So the before 3 years, patentee is not possible for satisfying the public. But after 2 years, when from you are getting the compulsory license, you want to try to satisfy the public requirement. So if you fail, the compulsory license will be revoked. So third one, the patent invention is not available to the public affordable price. So these are the ground your compulsory license will be revoked. So if you want to complete, if you want to overcome this criteria, these 3 criteria within 2 years. So after 2 years, automatically your compulsory license it will be revoked under the section 35 Patent Act 1970. So here I have mentioned, so what are the terms and conditions for compulsory license? Under the section 90, it is clearly denoted that the first one is the royalty and other remuneration, if any, reserved to the patentee or other person beneficially entitled to the patent is reasonable, have regard to the nature of the invention. So, I'm getting the compulsory license from any one of the patent means I want to give the royalty and the remuneration as per the prescribed time and prescribed manner. So that is the most important thing. Sometimes it will be happen the remuneration it is not reached to the particular inventor means the inventor is complained to the controller, immediately the compulsory license it will be revoked. So it will be happen that. So this is the first terms and condition of compulsory license. Second one, that the patent invention is worked in the fullest extent by the person. So what is the purpose of compulsory license? Before that, before 3 years, the patent is not worked very well. So only the compulsory license is provided to the third party with the permission of first inventor. So within 2 years, the compulsory who acquiring the compulsory license, he want to work full extent of that particular invention and making the reasonable profit. So this is the second terms and condition for the compulsory license. So third one, that is the patent article are made available to the public reasonable affordable price. So so I'm getting the license. So I'm already getting I got the license means. So I can I fix my rate for a particular product, a particular process. So that is not possible. So as per that, the patentee is not giving that particular product to the affordable price, then only the compulsory license issued for the third party. So the compulsory who holding the compulsory license, he also giving that that patent articles available to the affordable prices only. So next on the license granted is a non-exclusive license. Previously the Chelladurai sir has clearly mentioned that is exclusive license means if the patent, the first inventor is having the exclusive license. He have rights for giving the license to the anyone. But who obtained the compulsory license, he is not authorized person for selling the license for another person. So it is a non-exclusive license. The compulsory, who holding the compulsory license, who obtained the compulsory license, that person only utilize that compulsory license and making that disseminating that product and making the profit. So he is not eligible for selling again that licenses. So next is that the right of the license is non-assignable. The licensee, the license is not non-assignable. That assignee means what is that? The legal representative. Or yesterday I have mentioned that what is the who are all apply the patent. So first one is the true inventor, second one is the legal representative, third one is the assignee. So in this under the section 90, who hold the compulsory license, he is not an assignee. He is a licensed person who getting from the license from the first inventor with the permission of the controller. He is not an assignable person, so he is not eligible for selling or is telling it is disseminate this is my invention. It is not possible for that. He is one of the licensed person. He use that product and making the profit and giving the remuneration to the particular invention. But otherwise, apart from that, the compulsory license is not denoted that who hold the compulsory license, he is not the inventor or inventive person. He is not assigned by the first inventor. So that is the meaning of that. So next on this, the license for the balance term, that the license is for the balance term of the patent unless shorter time is consistent with the public interest. So what is the compulsory license terms? So how many years is left? Already 3 years left means. So again 17 years the compulsory license it will be with the effect if the person is satisfied the following criteria. So otherwise the compulsory license is immediately revoked by the controller. So next one is that is a license is predominant purpose to supply the Indian market. That license may also export to the patent product. So in that license is most probably most of the license as the intention for it will be disseminating to the Indian market. So but apart from that, if the compulsory license holder is having the interest, he having the wide scope about that patented product they export to the other country, it is the chances is it is possible for the under section 90, but the compulsory license is main motto is the patented product, the invention, it will be disseminate to the all over India. So that is the main important things. If he want to interest to exports, the market value is there in the other countries means it will be possible for under the section 90. So final slide. So penalties. So what are the penalties? What are the ground is available for the penalties? So there are different type of penalties is there. So if the inventor is going for legal with the legal patent agent means it is not a problem. But if failed, if he discuss with the patent agent, mean the patent agent know everything about what are the grounds it's available. So how we can fine tune our patent application. So how we can get the patent as soon as possible. But without the patent agent, so any person can directly handle any one of the brokers. So but he is not under the registered patent agent. That time, so some difficulties he might face. So what are the penalties under the section 118 to 124? It is detailedly described in the section. So first one is contravention of secrecy provision relating to the certain invention. So yesterday I have clearly mentioned the secrecy direction under the section 35. So if the invention is under the defense process, is a defense department, so that time, so it will be giving that controversy. So under the section 35, the secrecy provision, it will be effect to that in particular invention. So the controversy, if your invention is stuck in the controversy, so that time you have some penalties. Then falsification of entries in the register. So you know that you are getting one patent, but you can with that in this patent register you can giving the improper data or is a different title or different date. So anything it will be happens falsification entries in the register, it will be giving the big penalty for the inventor. Then unauthorized claim of patent rights. Unauthorized claim means already the claim is available, already the patent is granted for the particular claim, already the person is claimed already that claim is claimed by someone. So if you are claiming same things means that is not ethics for that. So that times unauthorized claim, the penalty it will be enforced in your enforced to the applicant. So wrongful use the word of patent office. You know, I know the patent office, I know the patent office people, I know the controller, I know the examiner. So this is not good. So wrongfully you are using any words about the patent office at any social media, at any cost. So that time you facing the penalties. If it will be it will be going for the serious issue. So next one is refusal and failure to supply the information. So any time, so previously I have clearly mentioned at any time the controller may before granting or after granting, at any time controller is called any person or inquire about the invention and asking for the document of the document for proof of our invention. If when this type of scenario it will become when the pre-grant opposition or post-grant opposition, when the before the patent grant anyone can file the opposition under the form 7A or post-grant opposition under the form 7. So in this case it will be acting for that the controller calling that any person as giving the summon for any one of the applicants. So he want to come and justify his claim, his invention is true. So if you are refuse and failure to supply or giving the information about your invention, the example for drawing and document or samples and or models, any what are the things the controller is asking. So you want to supply the document at the prescribed time and the prescribed manner. Otherwise, you have facing some penalties. And last one, next one is the practice by non-registered patent agent. You know, yesterday I clearly mentioned that patent agent exam it will be conducted by the Government of India under the Patent Act 1970. So you want to clear the 3 exams. So preliminary and the main exam, and you have cleared the interview also. So then only you have registered patent agent, you will get the registered certificate and the registration user ID and password. So then only you can act as a patent agent. But you are not writing this type of the exam, but you are acting illegally. As I'm a registered patent agent, you can giving the marketing like this. So if it will going to serious issue, that time you have faced the serious penalties under the section 118 to 114. So next one is offenses by the company. So it's offenses by the company means it's nothing but it's a corporate company is getting the patent means some of that infringement is like an infringement. So before I think 2-3 years before, some the controversy is coming between the Samsung and the Apple. So the Apple is mentioned that the Samsung is infringed by our invention. So that times the court case is favorable for the Apple. So that time the Samsung is giving for the huge penalties. So that type of offense it will be happen. So once you infringe your infringement of your particular invention. These are the penalties. It will be faced for different type of the, some penalties is for patent agent, some penalty for the applicant, some penalty for the company owners. So these are the penalties we can face for violating that when we are infringement our level. So under the section 118 to 124. That's it. So thank you. This is my end. So I hope last 3 day session we will give that overview of as much as possible. We can give the more content about the Patent Act and the patent filling and what are the different type of the intellectual properties available. So I hope you have the clear idea about that. If you have any queries, you may ask now. Dear participant, I have completed my session. If you have any queries during that last 3 day session, you may ask by the chat box or unmute yourself. The mic is yours. Anyone can unmute and discuss with me. So please.
One query is there in chat box. Check it.
Yeah. Okay, Rajesh. Okay. Sir, I have a question which I could not ask due to just 1 minute. Due to my internet connectivity, so we have to fill form typed or handwritten and scan it to upload the patent website. Yeah, yes, sir. No, recent days, so if you are going to the online application, everything is online only. So you don't want to upload, you don't want to fill the forms and submit scanned copy to the by the patent website. So it's not required. Everything is online only. You can fill out the form in online version, so you can submit it. So if you are going to submit your patent application by the physical mode, means that time it will be you can take the printout and fill out and submit that particular patent office which is nearer in your places. One more things I want to tell you. So in the patent office, there are different type of the patent office available. Yesterday I have mentioned. So in that patent office, how we can decide which patent office is I want to apply. So I am located at Chennai. So you are located. So I am located in Chennai means I am located in Agartala. So any one of the place, which is the nearer place of your patent office. There are 4 different patent offices there. If you are located in Chennai means you can go to the Chennai office. If you are located in Mumbai means you can go to the Mumbai. If you are located in that Tripura is northeast means you can go to the Delhi. So which is the nearest place you can go and file your patent by the physical mode. If you want to apply the patent by the online mode, the online form is available. You can directly go and give you a proper details, correct detail, you can submit it. But what is the important things is directly if you are going for anyone, no anyone can submit that application. So patent agent is required. So if you are going to the patent by the way of patent agent, so they will give the appropriate idea, everything. So you want to apply the individual, you can apply, but through the patent agents, if you are going, that is a good for smooth process. Otherwise, it will be creating a headache for the applicant. No, sir. Controller, examiner is a different person. The examiner. Controller is a final person. Once the examiner completing the examination of that particular patent, particular application, the examiner is submit to the report to the controller. Controller is only the final decision it will be take for whether the patent it will be granted or not. Is not a same person, it's a different. Dear participant, your interaction is the most important as. So I hope I'm also learner of Patent Act. I'm also doing and taking the sessions is recently. So this is my 4th session. So if I am if you are feeling like a unpleasant experience, means I ask your apologies from you. So I will improve myself also. So I'm also learning the Patent Act rules. So if you have any queries, please unmute yourself and discuss with me. So this is my humble request for you.
Sir, excuse me.
Yes, ma'am.
Sir, after filing patent, if I want to commercialize a product, can I go for it before getting the patent?
No, ma'am. Once patent is granted, then only you can go to the commercialization.
Because I think it will take more time for getting the
Yes,
patent.
ma'am. Yes, ma'am. Yes, ma'am. Yes, ma'am. That is, ma'am. That is, you can file that. Once you file that, submit the application, you can, along with your application, you can submit the Form 9, ma'am. It will be that earliest publication. Within 30 days, your application it will be published. Once the publication is came, you can immediately file the Form 18A. It is the expedited examination. So as soon as possible, within the 48 months, the examination should complete, but it's an ordinary case. If you file in the Form 18A, that time the examination it will be conducted as soon as possible.
So for expediting the process, whether we have to pay extra fees?
Yes, ma'am. Yes, ma'am. Yes, ma'am. Your normal examination fees is 4,000 rupees, but expedited examination fees you want to pay for 8,000 rupees for ordinary application for ordinary persons.
Okay, sir.
So,
okay,
but
sir.
yes, ma'am. Thank you, ma'am. But design pattern it will be easy, ma'am. So if anyone working in familiar to the design work, so if you getting the design pattern within 2 or 3 months, the patent is granted. So, but in that case, there is not required for the physical model or physical prototype. So only designs. If your design, if you feel your design it's a novel, it is not existing in that existing claim means you can submit your design pattern. So it will be get within 2 or 3 months. That is also one of the patent also.
Sir, for product patent, what is the minimum time it will take?
Minimum, the examination period is 48 months, minimum 3 years, they are mentioned. After the examinations, only the patent will be granted within 6 months. So maximum 3.5 years. But if you submitting your applications as soon as possible, the expedited yearly publication, expedited examinations, everything you publish, you can, we can complete the process within 1.5 years, 1 year, 1.5 years.
Okay, sir.
Yes.
Okay, sir. Thank you, sir.
Thank you, ma'am. Thank you so much, ma'am. So design patterns
I
are
have
moreover.
another clarification, sir.
Yes, ma'am.
I have developed one product and I should not publish that, isn't it, sir? I have
Yes, publish means you are
tested the efficacy of that product.
okay.
I'm from agriculture side. So I have developed one fertilizer formulation. I have evaluated that in a crop. Can I publish the outcome of that evaluation without disclosing the product preparation procedure? Is it acceptable or
Yes, ma'am. Yes, ma'am. You can initially you can submit your professional specification, ma'am. In the professional specification is the scope of invention and the title of the invention is a basic requirement only you want to give. So within 12 months, you can elaborately prepare your complete specification. You submit that respective patent office, ma'am.
Okay, sir. Before that, I should not publish the results in any journal.
No, ma'am. What? No, yeah, yes, ma'am. Yes, ma'am. You are asking the journal. You don't want to
Yes,
go.
sir.
You don't want to go to the publish the journal. Once you publish the journal, it is available in the public domain, na.
Yes, sir.
So that time, how you can claim that is your product is invention? That is for you. The journal is published by you, but it is already available public domain.
But if I am not disclosing the method of preparation of that product, then can I patent the method? or process of
Okay, ma'am. That is giving the difficulty, ma'am. That is because the title, it may be similar to the journal publication and the patent application. That time it will be showing for, everything is now is a digital. So if anything is every application is scrutinizing by the artificial intelligence. So the title is same from that your already available titles. Your mentioned title is the same, means that time you want to change something, alter something, you want amended your application, everything it will be happen, ma'am. Once the patent is published, then you are going to publish your journal, ma'am. That is the good for you.
Okay, but before grant of patent we can publish after
after patent, after once you complete the complete once you complete the complete specification, then you going to the publication, ma'am.
Okay, sir. Okay, sir.
Thank you. Sir, how much does it cost to file the design patent? I mean overall cost. So design patent also overall the 8,000 rupees, sir. So with the patent agent fees. So with the patent agent fees, the fees is 8,100 rupees.
Hello, sir. Good evening, sir.
Yes, sir. Yes, sir. Yes, sir. Good evening, sir.
So this is Hemant Kumar calling from Bangalore.
Yes, sir.
Sir, I have an invention and I'm planning to file patent for that. And I got a prior art search done by one of the agents actually. Now I have also the same invention. I'm also writing a public, in the sense, research article which I have sent it to the Indian Institute of Management, Shillong. Okay, so before I file my patent, is it okay if I present my paper, the same idea there in the Indian Institute of Management in the conference, or shouldn't I do that?
No, sir. You can no. What is that? You first complete your professional specification, sir. First you safeguard your idea. That is the most important thing. Once you once you present your article in the conference, anyone can come. Anyone, once you complete the conference, anyone can file the professional specification before you. Your application it will be rejected. So because your invention, but as per the record, another person is submit the professional specification, means that application only is validated by the controller. So what I am told, so first you complete your professional specification. You don't want to complete specification. So you register your idea, what are the things, what is the scope of the invention. So what are the things is required, you can file your professional specification. After that, your invention is secured. So once you the professional specification, from the date, your invention is secured. So before the date, anyone can get the invention, means they get the same claim, means that is a problem. But after the date of professional specification, anyone follow your process, or anyone follow your invention as a treated as a him invention, means that is not your problem. So first you register your professional specification, first safeguard your idea, then you can disseminate your idea through the conference and anywhere, sir.
Okay, sir, how to do that, sir? How to
professional specification? You can directly go on the patent website. You can directly submit. But if you are going to, but drafting is the most important thing, sir. Because as a researcher, we know that how we can write the abstract. But as a research paper, as a review paper, we can write the abstract and everything. But as a in the patent preparation, it's similar, but it's some differences there. So if you are going to some patent agent, so they will give that, you will give your idea, your document, what you prepared by yourself. He will convert it that as the requirement of patent.
Okay.
So you can contact to the any one of the patent agent, so he will direct it to you, sir.
Okay, sir, how much does it cost, sir, to register that?
For the professional specification, only 1,600 rupees, sir.
Okay, sir. How long will it take, sir?
Within 12 months, sir. Within 12 months, you want to complete your complete specification.
Oh no, because my conference is on November 21st.
So November 21st. Okay, is possible, sir. Is possible. If you are filing the professional specification, there is no examination, there is no process there. It's a simple application. You want to submit that application in that online portal by the patent agent or any one of the known person. It's a patent agent is a representative for this type of the work. So you can contact any one of the patent agents. So the conference date is November 21. So now today is more than one and a half month is there. The professional specification, there is no examination, there is no long process. You can directly upload your documents. What is your idea, scope of the invention you mention in the document, you can upload and submit the document. So once you submit the professional specification, so before you know that once you why I am told you contact to the any patent agent means, so you know your invention is the new, but it may be in the in India it may be already is available. So we don't know that how we can judge the patents already claim is available. It is like yesterday I mentioned the anticipation. So first if you are going to the patent agent first judge what you are claiming it's already available in the market or not. Once it is not available, then only patent agent process the further process. But if you are going, if you are directly going to submit the application, means it may be the idea is maybe available in the already the public domain, means it will be that your publication, your fees is waste, your application will be rejected. So you're facing a lot of consequences. So only I'm told you go to any one of the patent agent, he directed to you how we can process that.
Okay, it is called provisional specification, right, sir?
Professional specification, only 1,600 rupees you want to pay that. So if you have complete specification or you have the complete specification, all the document you have, means you can, along with the professional specification, you can submit your earliest publication, Form 9.
Okay.
So within 30 days, before the conference, your invention will be published. You can in this week or next week you can process that. The professional specification 1,600 and the yearly publication is I think 400 rupees. Sorry, 4,000 rupees. Earliest publication, 1 minute, sir. I will check. Earliest publications are 2,500 rupees. Totally 3,100 rupees only you want to pay. Both of that. 4,100 rupees you want to pay that.
Okay, sir. How long will it take, sir, for the provisional specification?
Provisional specifications validity for 12 months, sir. If you have all the idea, you can directly file your complete specification also.
No, my question is, how will it take that my idea is specified. My idea is I got the provisional specification. How long time will it take?
Provisional specification we can get 1 week or 10 days, sir.
Okay.
1 week is the maximum time. So once you completed that, you can you will the application number which will be generated. So in that application number, it's okay. So everything after that, anyone claiming the same your invention, you can legally take action against it. So first, what I tell, first you file the professional specification, safeguard your invention, then you can attend the conference or again you have process, you have continued that yearly publication and examination. First you file your professional specification. That is the most important thing, sir.
Sure, sir. I'll surely do that, sir. Sir, thank you very much, sir. Thanks for the information.
Thanks a lot. Thank you so much, sir. Thank you, sir.
Very valuable session. That's a lot.
Yes, sir. Thank you so much, sir. Thank you, sir. Any other person, do you have any queries? Okay, fine. Dear participant, I hope the last 3 days session it will be more helpful for you. I think more of yes, ma'am. Yes, ma'am.
I have a query. Is it possible to,
yes, ma'am.
Is it possible to patent a combo, means particle which is from a biological combo? Example, we isolated a fungal metabolite. Out of that, we are producing a zinc oxide nanoparticle or silver. Is it possible to patent those nanoparticle out of that fungal compound?
Yes, ma'am. You can process either that is the process patent. The product patent is different. The process patent is two categories there. You can patent your process whether the process is novel. It is not available in that market. Say no one can follow that process means you can file the patent, ma'am.
No, I'm asking, we can patent for that nanoparticle, I'm asking. That is not possible, right?
That is not possible. Nanoparticle, section 3(e) is clearly mentioned. So admixture of two components. So admixture of two components. If I mixing the two components, it will be generated for the third one. Okay, it will be happen for normally. So that is not eligible for the patentable, ma'am. Under the section 3,
Even
you can
it
follow.
is from a single pure compound of fungal metabolite, that is not even possible, right?
Yes, ma'am. For the component is not possible for patent. So the process you can patentable, ma'am.
Okay, okay. Thank you, sir.
Yes, thank you, thank you.
Sir, may I ask one more question, sir?
Yes, sir, yes, sir, yes, sir. Sure, sir, sure, sir, sure, sir.
Sir, can we patent a business idea?
Sir, I'm not understand, sir.
I have an innovative business idea that is not presently available. Okay, can we patent that idea itself? Business
No,
idea?
sir, no, sir. No, sir. Patent idea is not patent. Any method of information you want to present the information, that is not patentable, sir, under the section 3.
No, it is a process of conducting a business. It is not information. It is a process in which I conduct a business.
No, sir. You can go to the copyright. It may be you can create in a literary document. So you can copyright that document. That process is the copyright. It is not patentable.
Okay, sir. Thank you very much. Thanks a lot.
Yes, sir. Literary document you can create.
Okay, sir. Thanks a lot.
Yes, sir. Thank you, sir. I hope the last 3-day session is most useful for everyone. So kindly, this is we came that the conclusion session. So your feedback is most essential for us. Already we shared our Google review and Google form for submitting your valuable feedback for what you think about last 3-day session. So this is the validity function. So if you want to share your feedback by the mic, so you can unmute yourself and share your feedback. So what are the things I want to improve? We want to improve. So what you feed last 3 days? I think you are paying money. So I'm not taking the free class. So you are paying the money. It is useful for you. So kindly give your valuable feedback. It will be more useful for us to conducting this type of the workshop in the future also. So kindly unmute yourself. Please share your feedback, valuable feedback, please.
May I, sir? This is Hemant
Yes,
Kumar
sir.
from
Yes, sir.
Bangalore.
Yes, sir. Sure, sir. Sure, sir.
So I'm talking again. I'm really sorry.
No,
But
sir. I'm waiting for talking, sir.
But this was really informative. That I have been attending the session since the day one. But though I joined the day one session very late, but the rest of the 2 days I complete sessions, and all the speakers and everybody has been to the top notch. They have done a beautiful job, and they've given a complete clear idea about how patents have to be taken here. Okay, and I just asked you a question about the provisional specification, which I actually did not know. Though I'm doing my PhD in the intellectual property rights, but my PhD is into the MSMEs, how IPR is applicable in MSMEs. But the provisions or the provisions actually I did not know. So, but now because of this session, I came to know that I need to get the provision specification. That is really informative for me. That has saved me a lot of my ideas before it is stolen by someone else. Okay, this is my heartfelt thanks to the whole team and all those speakers who have done this. Okay, thank you very much.
Yeah,
Thanks
thank you so much, sir. One for information I want to share, sir. I know some of the patent agents, sir. So if you want to know about any patent agents, if you want to any contact information to the patent agent, you can directly use the WhatsApp group, sir. I will share the contact detail to that, so you can utilize that.
Yes, sir. That would be really kind of you if you can share some numbers over there, so that that will help us.
Sir.
Will help us. Thank you very much, sir. Thanks a lot.
Yeah, thank you so much, sir. Thank you, sir.
Hello, sir.
Yeah, yes, sir.
Yes, sir. Good evening, sir. This
Good
is
evening, sir.
Dr. M.Sc Ph.D. from Srivakalam, Andhra Pradesh.
Yeah, sir. Yes, sir. Thank you, sir.
First of all, I convey my gratitude and sincere thanks to scholarsgate for conducting this international workshop on intellectual property and rights. Very nice workshop, sir, for the research people.
Yeah, yes, sir. Yes, sir. Yes, sir. Thank you
Right
so
now,
much for your
right.
appreciation, sir.
Yes, sir. This is right now everybody needs IP or intellectual property rights subjects, sir. So far we have published some papers, but now we need the knowledge of intellectual property rights. So these 3 days, the resource persons have given more idea regarding intellectual property rights. So we grabbed some knowledge. With that knowledge, we are going to file IPR patents, sir. So
Yeah.
very kind of you, sir, and Chaladore, sir, for your motivative and lucid presentations in the sessions. And once again, I convey my sincere thanks to all the organizing team for making this workshop a grand success. Thank you, sir.
Yes, sir. Yes, sir. Thank you so much for your valuable feedback. So it will be more energetic for us. So because nowadays we are conducting the so many workshops. So in this topic is more important because after the 2021, the PhD, all the PhD scholars should study this subject. So there is no credit, but all the PhD scholars should study this subject. So that is the good initiative for the known all the peoples about the patent laws, what are the things it's available. So only we are selecting this topic. I hope this topic will be more helpful for you. Thank you so much for your valuable
Yes,
feedback,
sir. We
sir.
are
Thank you, sir.
expecting some more workshops in future, sir.
Yeah, sure, sir. Sure, sir. We are
Sure, sir.
we,
Thank
we
you
are
very much, sir.
yes, sir. We can continue that workshop also, sir. So thank you so much, sir. Please connect with us, sir. Thank you, sir.
Okay, thank you, sir.
Thank you so much, sir. Anyone? Your feedback is most helpful for us because
I want to give my sincere feedback to you all.
yes,
Your
sir.
session was fantastic. The other
Yes.
person also was good, but the problem is the internet connection.
Internet connection.
I think internet connection should be up to the mark. This is my honest review. Okay.
Yes, sir. Yes, sir. Yes, sir. I
Please don't take
understand.
me the wrong way. It is just for your betterment, and I just believe in constructive feedback. That's all.
Yes, sir. Yes,
If
sir. Yes, sir.
that would be sorted out, I think it would be one of the best sessions around. And this is my sincere request for you also. Okay. Thank you.
Yes,
Thank
sir.
you once again. Okay.
Yeah. Thank you, Sushil sir, for your your valuable feedback about the event. Thank you. Thank you so much, sir. Any other participant? Arulmati ma'am?
Yes, Shatish, Dr. Shatish. I'm happy to give my opinion on this forum. Actually, sessions went good. First day, he thought that it is due to Webex, but I'm attending more than 4 or 5.
Yeah. Your name I seen frequently, so only I am calling your name, ma'am. Thank you so much for register the event and believe the scholarsgate, ma'am.
Yeah, you come with the idea or topics which are need for their are especially for the scholars and researchers who are engaged with the activities, especially like AI in writing and everything. So this session is also good, but we can if the internet connections and all everything
Yes, ma'am.
went
I'm
good,
deeply
the session
regretted
would
that,
have
ma'am.
come with more ideas, right?
Yes, ma'am. Yes, ma'am. I regretted that that will be happen, but
This is from the other and not from yours, but anyways, we are happy for scholarsgate with bringing this IPR session. Thank you so much.
Yeah, thank you so much, Arunmati ma'am, for your valuable feedback. So it will be more, it will be giving the more energy to us, ma'am. Thank you so much. And yes, ma'am, you will join the more sessions in future also, ma'am.
Sure, definitely.
Yes, ma'am. Thank you, ma'am.
Okay.
Any other participant you want to register your feedback, please. The mic is open for you. Okay, fine. One more time, I want to send my gratitude to each and every participant for giving this wonderful opportunity to conduct this 3 days intellectual property rights and workshop. So I hope we will cover the moreover all the topics which is under the Patent Act 1970. So already yesterday I shared the book details. You can buy that book, so you can. I followed that book only, so you can buy and start reading your book. So after that, I want to give one more addition. So this session, you know, Chaladurai sir has told the patent searching option. So patent searching, the Indian, you know, that website you are only searching for the Indian patents. So if you want to search the patents the international level, means you can follow this website, free patent search. You know, this is the patent, what are the patents office that granted the patent? There are different type of the patent office. All the patent office granted patents available here. You can search your what is the requirements. Example, I am working in the orthopedic material, biomaterial means I am simply putting the biomaterial means what are the patent is granted from the last 50 to 60 year data, it will be shown here. So this is the most important forum. So you can find out the international level patents, what are the registered as for now. So I hope this is more informative for you. The patent website detail I will share the WhatsApp group, so you can go and check whether your idea is already patented or not. So it will be more helpful for you.
One question I have.
Yes, sir.
I mean, you told about the patent. People who do it, correct? You know, some people who can help us do it, who are registered patent attorneys or something of that sort. But what is the charge that I'm looking at by their end? I mean, a rough idea.
No, sir, I don't have any idea about the patent. Different upon the difference. So depends upon the patent agent. They are asking the money for that work. Well, I will check and let you know, sir. I don't know clear idea about that now.
Okay.
Yes, I will check and let you know, sir. Roughly,
Sure.
No, sir, I don't have idea roughly.
Yeah,
Also.
and I'll see you in AI tools for research and publications.
Yes, sir. Thank you, sir. Thanks for registration, sir.
See you. Thank you. Have a good day.
Yes, sir. Thank you, sir. Dear participants, any other queries, any other feedback you want to register, so you can use this forum now. Otherwise, we can wind up the session and we can meet next occasions. It will be on 14th to 16th October 2024.
Sir, can we get the video recordings or
Yes, ma'am. Already we shared the last 2 day recording. Today recording I will share with tomorrow, ma'am.
Yes, sir. Thank you, sir. Thank you.
Yes, thank you. Okay, thank you so much, everyone. So kindly submit your both feedbacks and the Google review and the Google form. So it will be more helpful for us for conducting this type of the workshop in the future also. Your certificate and video recording, video recording, it will be reached tomorrow. meeting, I think last 2 days PPT is already shared by WhatsApp group. So today PPT I am also shared by the WhatsApp group now. When we are distributing the certificate, that time the mail contained to that 3 days video recording link and what are the document we are used during the session. So it will be placed that it will be reached for officially. So if you want to use that PPTs, I will share the group now. You can use that PPT before that. So your certificate and your your certificate and meeting, video recording and the document, everything it will be reached for within 48 hours once the event is completed. So within 48 hours we will distribute all the certificate. First of all, once you submit the feedback, then only we can initiate this process. So kindly submit your feedback, both feedback before tomorrow afternoon 12 p.m. So after that the link will be deactivated, so we can start the certification process. So if you complete as soon as possible, so we can complete the process smoothly as soon as possible also. So thank you so much for giving this wonderful opportunity. We will meet another occasion from October 14 to 16. So until thank you and everyone, bye bye. Rajesh.